Good morning, ladies and gentlemen. We have the privilege of living in a free and democratic society. And the continued existence of that free and democratic society depends on the law. Lawyers, as guardians of the law, play a vital role in the preservation of that society. And the fulfillment of the role as a lawyer requires unwavering commitment to the core values of the legal profession. And a consequent obligation is that lawyers must maintain the highest standards of ethical conduct. And that's what this case is about. It's about lawyers and ethics. The scales of justice sit firmly on the book of ethics, and justice cannot exist without ethics. Ethics are at the very heart of the legal profession. The legal profession would not exist without ethical standards. Without ethics, the legal profession cannot survive. Without the legal profession, law cannot exist. And without law, our society as we know it would disintegrate and crumble. In the nature of law practice, however, conflicting responsibilities are encountered. Sometimes lawyers have to make choices, and those choices arise between a lawyer's responsibilities to clients and to the lawyer's commitment to the ethical standards of the legal profession. I knew I was going to laugh. Such issues must be resolved through the exercise of professional and moral judgment, and a lawyer should not be made to fear retribution in the exercise of this judgment. What then becomes the sanctity of our legal profession if we're expected to abandon the very principles at the heart of it based on clients' whims? This case may be about one lawyer and one law firm, but it's about more than that. It's about the future. What if all law firms decide that client interests and money is more important than maintaining the ethical standards demanded by our profession? That's why you, ladies and gentlemen, have an important job today. In fact, it might be the most important job you do in your lifetime. You have all the power. And I ask you to use that power to protect the future of the legal profession and the future of our free and democratic society as we know it. If law firms are allowed to treat their lawyers the way Morgan and Sterling treated Harvey, well, then that threatens the world as we know it. So thank you. Thank you for agreeing to do this job. Thank you for your commitment to your job as jurors. Thank you for your patience and your attention. I told you at the beginning of the case that you are the judges of the facts, and you have taken that job very seriously. You have shown up on time, have listened attentively, and now you have the difficult task of culling through all of the evidence and complicated law to come to a verdict in this case. We are grateful, and Harvey thanks you. But I also told you at the beginning of the case, when you go back to the verdict room and look at the verdict form, you'll realize that this is a pretty simple case, and the answer will be clear to you. A lawyer should not be forced to abandon and ignore his ethical obligations to fulfill unreasonable client mandates. A law firm should have more commitment to its hardworking and talented associates than to just fire them at whim. This case is about ethics versus money. It's about a young, talented lawyer who had to make a tough choice and received a harsh and cruel punishment for it. The harshest and cruelest punishment a lawyer could think of. The humiliation of being fired. The withholding of a bonus that he had worked tirelessly for a year to earn. The inexplicable trashing of his outstanding reputation. A shameful homecoming, and then desertion by his spouse. All of this for 2 weeks. A 2-week extension. A 2-week extension over Christmas and New Year's, when not much work is done anyways. Now, as you are back in the jury room, ask yourself, did Harvey Gorman deserve to be fired without an explanation or without an opportunity to defend himself? Did Harvey Gorman deserve to have his name trashed to all the other big firms? Did Harvey Gorman deserve to be forced to retreat to his hometown and live a very different life than he intended and had imagined? And for what? Asking for a 2-week extension? You have now seen and heard from Harvey Gorman. Harvey was an excellent attorney at Sterling & Morgan with a flawless record. After only a year at the firm, he was running his own cases, doing all the work from discovery to trial. He was highly regarded and recognized for his talent and judgment and work ethic. He had received an outstanding third-year review and was put on the prestigious SciLab team. You heard that it was understood that SciLab was reserved for only the best associates. Harvey told you it was even nicknamed the Superstar Team. He joined that team in September of 2013, and in just 4 short months, he had been instrumental in 4 successful outcomes for the client. He had served SciLab well, and it wasn't a fluke. You've heard that he served all of his clients well, and no partner ever told Harvey he was doing anything but a fantastic job. And no witness has taken the stand at this trial and testified that Harvey was anything but a superb attorney. He was never accused of being a procrastinator. He was never accused of being incompetent. And he was never accused of violating clients' policies. In fact, the opposite is true. The reasons Morgan and Sterling have given you for firing Harvey couldn't be farther from the truth. Each year, the partners raised Harvey's salary. Each year, he received a bonus. And bonuses are only earned through, as you heard, blood, sweat, and tears. They were only given to the most outstanding associates. And the last bonus he received, $25,000, was reflective of an exceptional performance. And that is precisely what Harvey did to earn those. So based on all of this, Harvey had every understanding that he would be made partner. And why shouldn't he? Wouldn't every law firm like to have a partner like Harvey Gorman? He had every reason to believe that, based on the work he'd been given, the clients he'd been assigned to work for, the performance evaluations he received, and the compensation he'd been paid. But it wasn't just those things that gave him the understanding that he would be made partner. He was told he would be made partner. And not just on one occasion. He was told on multiple occasions that he was going to be made partner at Sterling & Morgan. At the end of his 3-year evaluation, he was told by partners, "You'll make partner in no time." When he talked to somebody about moving to the U.S. Attorney's Office, the person said, who was also a partner, "Wait until you make partner." Harvey relied on those promises. He did stay. He was waiting to make partner. He never planned to return home. He was dedicated and committed to making partner as he'd been told. He was presented with a tough situation in December of 2013. You've heard that he was given an assignment to proofread and finalize for filing certain discovery responses. He told you he never expected it to take more than an hour to do. He had no way of knowing that it would take more than an hour. So you've been made to believe that there are 2 weeks of time where he could have completed the assignment while Mr. Sterling was in town. But that wasn't the assignment. The assignment that Mr. Sterling gave was for him to finalize and file the discovery responses on December 20th, because Mr. Sterling would be out of town on December 20th. If the assignment could have been completed while Mr. Sterling was in town, then Mr. Sterling could have done it. The point was Mr. Sterling needed Harvey to finalize and serve the discovery responses on December 20th, when they were due. Sterling surely didn't expect Harvey to go through and check his work. He's a senior partner. His assignment was to get it filed. But Harvey, being the conscientious lawyer he was, did more than that. He went above and beyond what was expected of him. And he did review the file and did review the responses. And he did that 2 days before the responses were due. In fact, he felt like he was actually getting a head start on this assignment, since he only thought it would take an hour. And when he realized that there might be a problem with the responses, he did what he thought was best and tried to contact the senior partner on the account. Why? Why didn't he try harder to get in touch with Mr. Sterling? Why didn't he ask someone else in the firm what to do? Why didn't he ask the client what to do? Well, Harvey admitted to you that may have been a mistake, but he did what he thought was best. He thought he was protecting Mr. Sterling because he wanted to talk to Mr. Sterling about the situation first. So he made a tough choice, but a choice that he believed was the lesser of two evils. He made the choice to get a 2-week extension. Thought this would give him time to talk to Mr. Sterling, even though he knew that SciLab did not like extensions. But he told you that he was fearful that the court would ultimately exclude the video as sanctions for failing to disclose it. A video that could win the case, he told you. Or worse, that he, Sterling, or the entire firm could face discipline from the bar. That may have been the wrong choice. But is it a choice that he deserved to be fired for? Did Sterling and Morgan have no other choice but to fire him? Are we as lawyers held captive by clients and forced to cater to their every whim? And the answer is no. They could have taken him off the case. They could have waited for things to cool down. They could have done a number of things without firing him. So, as I said, Harvey admits he made some mistakes. But what's clear from the evidence is that there are 4 truths that resolve this case. Harvey was right. You saw that Mr. Sterling ended up filing the responses as Harvey had recommended. SciLab was not prejudiced at all. The deposition was taken on time, and it was only 2 weeks over Christmas and New Year's, when not much work is done anyways. Firing was a harsh and unwarranted punishment for Harvey's actions in light of his prior performance. And finally, no lawyer should be made to set his ethics aside in the interest of an unreasonable client mandate. So what are we asking of you? You heard Mr. Monet come and tell you the economic loss that Harvey has suffered. And that's all we're asking for, the economic loss. We're not asking for any mental pain and suffering that Harvey's suffered from Sterling and Morgan's actions. So as you go through the verdict form, I ask that for question 1, you check yes, that he did have a contract. For question 2, if you get there, I ask that you answer yes. Was his discharge a violation of public policy? For question 3, was he discharged for just cause? I ask that you answer no. And the final amount of damages, you heard Mr. Monet tell you that it's about $8.3 million that will fully compensate him for his economic loss. And this is just a fraction of what Sterling and Morgan will make over their lifetime. Help make Harvey whole. Thank you. Good afternoon, ladies and gentlemen. Again, my name is Bethany Schneider, and I had the pleasure of speaking with each of you during voir dire. Again, it's my distinct privilege to represent the defendant in this case, Philip A. Cup. Now, as I was listening to Ms. Logan's opening, I was reminded of a radio program that ran from World War II to actually 2009 with a host named Paul Harvey that's called The Rest of the Story. Part of that radio program was to tell stories that had forgotten facts or little-known facts that at the end of the program, he would reveal the key fact. And when he did, he would use the tagline, "And now you know the rest of the story." Ladies and gentlemen, that's my job here today as defense counsel. It's to bring you the rest of the story. It's to bring you, as judges of the facts, the rest of the story that you need to know to make a determination in this case. That's what you are. You are the judges of the facts. The court will give you the law, but you're going to take all of the evidence in this case and decide how to apply those facts to the law. The good news for you is that when you get to the end of the case and you've sat through all of the evidence, you'll find out that this is actually a pretty simple case. This is a case that boils down to carelessness and distraction and taking personal responsibility for that carelessness and distraction. So I want to spend some time going through those claims with you and showing how the evidence that you'll hear in this case goes with each of those claims. So the issues you're here to decide. First, who was at fault for the accident? Now you heard the plaintiff's side of the story. So the rest of the story is that you'll hear Mr. A. Cup tell you that he took all of the necessary and appropriate safety precautions that day on November 18th. But what you'll also hear is when the plaintiff, Ms. Hertz, gets up to testify, she'll have to admit that she was preoccupied that day with an important presentation that she was going to give, that she was in a hurry because she had overslept. Now, the plaintiff's counsel told you that she had time to stop for coffee and a newspaper, as was her routine. But what you'll hear is that no one reported any coffee or newspaper at the scene of the accident. You'll also hear that just minutes before her presentation was set to begin, the meeting was set to begin at 8:45, she steps off the island in the middle of the street, not even looking for the walk sign, and outside of the crosswalk. Now the second issue for you to decide is what injuries, if any, were sustained as a result of this accident. So what you'll have to decide is the emotional and psychological problems that Ms. Hertz will explain to you, were those a cause of this accident or something else? And what you'll hear is that Ms. Hertz, unfortunately, had her mother pass away just a week after the accident. The final question for you will be, how much should Ms. Hertz be compensated for her injuries? So for that question, you'll have to take into account, was she really up for promotion? How long had she been suffering the injuries that she claims? And is she still suffering those today? And has she tried to get another job to mitigate her damages? Another less stressful, challenging job that maybe could help her financially. So I'm about to sit down, ladies and gentlemen, but I want to ask you just to do one thing. As you promised to do in jury selection, because the plaintiff gets to go first, I just ask you to keep an open mind and reserve judgment until you hear the defense side of the case and the rest of the story. Good afternoon, Mr. Acup. Good afternoon, ladies and gentlemen of the jury. Now, Mr. Acup, we met at your deposition in this case, but to reintroduce myself, my name is Bethany Schneider, and I represent the victim in this case, Meg Hertz. Now, I'm going to have a few questions to ask you about what happened on November 18th, 2013. And I've got your deposition here just in case we need to refer to it, okay?
Okay.
All right. So, Mr. Acup, I want to start out by asking you some basic questions about safety rules of the road, okay?
Okay.
Now, as you told this jury, you've been a bus driver for 9 years. Is that correct?
That's correct.
All right. And so, of course, you know that one rule every driver learns is that in driving school is to watch out for and yield to pedestrians, correct?
Absolutely.
All right. And that's one of the basic elementary rules of driving on the road, correct?
Correct.
Pedestrians always have the right of way. Isn't that true?
That is correct.
Actually, as you're driving around, signs are everywhere. It's the law to stop for pedestrians in the crosswalk, correct?
Absolutely.
You agree that watching out for pedestrians is one of the most important aspects of your job, transporting men and women around busy intersections like the one at issue in this case, correct?
Yes, ma'am.
And along with the rule of watching out for pedestrians, when you're driving is being aware of whether a walk sign is illuminated, correct?
Correct.
And when those walk signs are illuminated, pedestrians have the right of way to cross the street, correct?
Correct.
And it's your duty as a driver to be aware of whether the walk sign's illuminated or not, correct?
That is correct.
And as important as it is to pay attention to whether the walk sign is illuminated when you're making a left turn, you didn't do that on November 18th, 2013, did you?
I couldn't recall specifically when I met with you.
Before you slammed your bus into the side of Miss Hertz's head, you didn't see whether you had the right of way or whether the walk sign was illuminated, did you?
Before Miss Hertz walked into my bus, I do not recall whether the walk sign was on, but the crosswalk was clear.
Well, we're going to get to talking about whether it was Miss Hertz that walked into the bus or whether it was your bus that slammed into her. But for right now, my question is, you can't tell this jury sitting here today whether the walk sign was illuminated or not, can you?
I can't, that's true.
So the walk sign could very well have been illuminated when Miss Hertz was crossing the street. Isn't that right?
The walk sign could have been illuminated.
All right. You have no way to say whether it was or not because you never looked, did you?
Well, I was looking at the crosswalk which was empty, but I don't recall looking at the sign.
Right. So not only are there rules of the road, there's also laws, correct?
Correct.
And in order to receive your license to operate a commercial bus, you have to take certain safety classes, correct?
Absolutely.
And you completed safety classes in order to obtain your license, isn't that right?
That's correct.
In fact, Bancroft Bus Lines. Good afternoon, Mr. Acup. Good afternoon, ladies and gentlemen of the jury. Now, Mr. Acup, we met at your deposition in this case, but to reintroduce myself, my name is Bethany Schneider, and I represent the victim in this case, Meg Hertz. Now, I'm going to have a few questions to ask you about what happened on November 18th, 2013. And I've got your deposition here just in case we need to refer to it, okay?
Okay.
All right. So, Mr. Acup, I want to start out by asking you some basic questions about safety rules of the road, okay?
Okay.
Now, as you told this jury, you've been a bus driver for 9 years. Is that correct?
That's correct.
All right. And so, of course, you know that one rule every driver learns is that in driving school is to watch out for and yield to pedestrians, correct?
Absolutely.
All right. And that's one of the basic elementary rules of driving on the road, correct?
Correct.
Pedestrians always have the right of way. Isn't that true?
That is correct.
Actually, as you're driving around, signs are everywhere. It's the law to stop for pedestrians in the crosswalk, correct?
Absolutely.
You agree that watching out for pedestrians is one of the most important aspects of your job, transporting men and women around busy intersections like the one at issue in this case, correct?
Yes, ma'am.
And along with the rule of watching out for pedestrians, when you're driving is being aware of whether a walk sign is illuminated, correct?
Correct.
And when those walk signs are illuminated, pedestrians have the right of way to cross the street, correct?
Correct.
And it's your duty as a driver to be aware of whether the walk sign's illuminated or not, correct?
That is correct.
Actually requires you to take additional safety courses, don't they?
That is correct.
And in fact, they require you to take these courses on a regular basis, correct?
That's correct.
To make sure you're aware of any new laws that come out that would affect your driving on the road, right?
Absolutely.
And in those safety classes, they teach you the traffic laws, correct?
Correct.
And it's very important as you're driving to be aware of all traffic laws, right?
That's correct.
And as a bus driver, you want to obey those traffic laws, don't you?
Of course.
You mentioned that you were in line for promotion at the time of the collision. The jury has heard some suggestion that you actually had an unfavorable evaluation and were not in line for promotion. Is that true?
I believe the last formal evaluation that was done by Ralph King, who was my supervisor at the time. He thought that I did an adequate job, at my position, but that he didn't see any motivation for promotion and movement on my part. But we had worked those things out, and he actually was instrumental in organizing the presentation, helping me to make the presentation to the board of directors. I had worked on a project that was going to save the company a good deal of money, and Ralph was very enthusiastic about this, and he was the one that suggested that a promotion possibly a presentation.
Okay, so it was Mr. King who actually put you up for the promotion in that presentation. Is that right?
Yes.
Is that what you're saying?
Yes.
Okay. What was the date of that evaluation?
That was it was quite a while before the accident. Maybe, again, my recollection is not great with dates and things. It might have been a year and a half before.
Okay,
Something
well,
like that.
would you like to take a look at your evaluation?
Sure.
Maybe that would help you. Is this the evaluation that we've been discussing?
Yes, it is.
Do you see the date here? January
Yes,
15th,
so-
2013?
Yes.
When was the accident?
So November of 2013.
So was there
it
some
about
time?
almost a year. Yeah.
Did you have to go to the hospital
Yes.
after you were hit?
Yes, I did.
Were you in any pain?
Oh, yes. I had a headache. Felt like my head was in a vice. My neck was stiff as if it had been whiplash. I felt really groggy, confused, and I'm also, it felt frightening to come to with a lot of people crowded around me asking questions.
Did you have to be strapped in as you're being transported to the hospital?
I did. The paramedics strapped me to a board and put a neck collar on me, and I'm a bit claustrophobic, so that was really sort of torturous. And I asked if they had to do that, and they said that was the normal protocol for any possible head, neck, or back injuries.
Now, the defense has suggested that all of the emotional and psychological injuries that you suffered are actually due to the fact that your mother passed away about a week after the accident. Can you please tell the jury how your mother's death affected you?
My mother and I had a bit of a distant relationship. I was really raised by my grandmother, who passed away when I was in college. My mother had a drinking problem, and as a result, she had a long illness with cirrhosis. She was suffering a great deal. I didn't see her very much, but of course it was, I was so sorry about her condition, but at the same time a little relieved at her passing because she really was suffering so much and so much pain. She felt that it was time to go.
So do you think that the emotional and psychological injuries that you're suffering today are caused by your mother's death?
Not at all.
And in this case, you were asked to do an evaluation of economic loss for the plaintiff, Mr. Gordon, correct?
Yes.
On average, you do about 20 or 30 of those evaluations per year, right?
That seems about right.
And a majority of those evaluations are for plaintiffs as well, correct?
I'd say the majority, but not all, but yes.
But the majority are for plaintiffs, right?
Yes.
You charge $5,000 to complete these evaluations, isn't that right?
Mm-hmm. Yes.
And that's what you charge in this case.
Yes.
So I'm gonna take this marker here, and I know I'm not the mathematician, but if you do 20 to 30 evaluations per year and charge $5,000 per evaluation, that is $100,000 to $150,000 a year just based on doing those evaluations, right?
Yes, that's right.
And that's not counting the salary that you get in your day job as an assistant professor, isn't that right?
Yes, correct. That's a different salary.
Over the course of your career then, since you said you've been doing this for 20 years, just to do these evaluations, you made $2 to $3 million, correct?
That seems about right. Yes.
And that's significantly more than what you've been paid as an assistant professor. Wouldn't you agree with that?
Yes, it is.
And these figures don't even include the hourly rate that you charge to actually testify in a deposition or at trial as an expert witness, right?
Yes, that's a separate charge, which is not very different than you'll find across the field.
Okay, but you do charge an hourly rate when you testify at a deposition or a trial, like you're here today, correct?
Mm-hmm.
And that's $450 an hour.
Yes, it is.
So in addition to that $2 to $3 million over the course of your career that you've made from the evaluations, you've also made whatever hourly rate, $450 an hour, for the 3 to 4 trials a year plus any depositions you've given. Isn't that right?
If it requires it, yes, that's it.
And just like we talked generally, your evaluations are based on facts and assumptions, correct?
Mm-hmm.
So I want to go through with you the facts and assumptions you based your opinion on in this case.
Okay.
Now the first fact that you based your opinion on is that Mr. Borman will retire at age 68. Is that right?
Yes, that's one assumption you made.
And to arrive at that figure, you looked at two things, correct?
Yes.
One was the statistics on retirement age that you got from the U.S. Department of Labor, right?
Mm-hmm. That was one of them.
And according to that government publication, Mr. Borman's statistical work life would be 64, correct?
Yes, we also relied on actual conversations with Mr. Gorman too.
And I'm getting to that, but just for this question, according to the statistics that you looked at, his retirement age would be 64, right?
Yes.
That's 4 years younger than the age you chose, correct?
Yes, that's right.
And the reason you chose a higher age was because you had a discussion with Mr. Gorman, correct?
It was that among other things, but yes.
All right, well, let's talk about the discussion you had with Mr. Gorman. When you talked with Mr. Gorman, he told you that he believed he would work until age 70 because he's in excellent health and has a desire to work in the legal field, correct?
Yes, that's right.
You'd agree with me, Mr. Monet, that people's health can change, right?
It can, yes.
And you'd agree, Mr. Monet, that a person's desire to do a job can change, correct?
I mean, anything can change, yeah.
Right, anything can change. Isn't that right?
Mm-hmm.
Neither are absolutes, are they?
In this case, no.
But you took Mr. Gorman at his word, didn't you?
Yes, I did.
And you chose a figure that was different from the government statistics in considering your opinions.
And being fair with it, though, I also didn't choose only his number. I came to a number that was between the government statistic and what he provided to me too.
But you'll admit that choosing the age 68 was a matter of judgment, wasn't it?
Mm-hmm. Yeah.
Isn't it true, Mr. Monet, that you made no attempt to determine what the average retirement age was at Sterling and Morgan
No, I did not.
or any other comparable firm, did you?
No.
So, let's be clear. This is an assumption, correct?
That is an assumption.
The next fact that you based your opinion on is that Mr. Gorman would become a partner at Sterling and Morgan, correct?
Yes.
And that's based solely on what you were told by Mr. Gorman and Mr. Gorman's lawyer, isn't it?
Yes, he said that through other conversations that he was looking to be a partner, and other members of the firm had told him the same way.
You didn't talk to those other members of the firm, did you?
I did not know.
As someone who does a substantial amount of litigation work, you're familiar with the firm Sterling and Morgan, right?
Fairly, but yeah.
You know it's a prestigious firm, correct? And you know that not every associate who works at a big prestigious firm makes partner, do they?
No, I wouldn't think that anyone would.
Most times it depends on the individual circumstances, correct?
Yes.
In fact, you're aware or not that 5 out of the 8 associates in Mr. Gorman's class did not make partner when they were up this past year.
Yes.
The same year that Mr. Gorman would have been up for partner, right?
No, actually, I'm not aware of that.
Okay, well, you'd agree that that would be important information to know in considering your opinions, correct?
If they were the ones that I was doing the report for, but it was for Mr. Gorman, it was not one of those. He did not have that opportunity to.
Right, but when considering in your opinions that he would become partner, wouldn't it be important to know if the firm's actually making people partner?
It would be, yes.
Isn't it true you did not undertake any investigation into the requirements for partnership at the Sterling and Morgan?
No, I did not look into that.
You have no knowledge of partnership criteria at Sterling and Morgan, do you?
No,
And you don't have any knowledge whether Mr. Gorman actually met that criteria, do you?
other than conversations I have with Mr. Gorman, no.
And you've not received any independent information other than from Mr. Gorman or Mr. Gorman's lawyer about his prospect for making partner, do you?
No.
So you'd agree then that this is also an assumption.
Yes.
And you understood that when you issued your report, you were supposed to provide all of your opinions in this case, correct?
Correct.
But you didn't mention anything about Ms. Hertz's mother in your report, did you?
That's correct.
In your report, you concluded that Ms. Hertz had major depressive episode, correct?
Correct.
Now, you told this jury that you're board eligible, right?
That's correct.
You're familiar with the American Board of Psychiatry and Neurology, correct?
I am.
That's the board certifying authority, right?
Correct.
In order to be board certified, you have to take an exam, correct?
Correct.
Isn't it true that board certification is a distinction for doctors who pass that exam?
It varies depending on who you talk to.
Well, isn't it true that when doctors call themselves board certified, that means they've passed an exam?
Correct.
You haven't passed that exam, have you?
I haven't taken the examination.
Okay, so you haven't taken or passed the examination, correct?
Correct.
So you're not board certified, are you, sir?
That's correct.
Now, isn't it true, Dr. Neuro, that the board actually discourages the use of the term board eligible because it's misleading?
That's correct.
And you're aware that, in fact, the board actually puts on their website that they don't recognize that term.
That's correct.
Let's take a look. Right on this website of the American Board of Psychiatry and Neurology, it says, the ABPN does not recognize or use the term board eligible and does not issue statements concerning board eligibility. You would agree, sir, that it's important for you as a physician and as an expert to understand a patient's complete medical history in order to assess the cause of symptoms, correct?
Yes, absolutely.
The first time you said that you ever treated Ms. Hertz was December 30th, 6 weeks after the accident, correct?
Correct.
You were not her primary doctor, were you?
No.
Dr. Bombay was her family doctor, correct?
That's correct.
And she saw Dr. Bombay before she came to see you, didn't she?
I believe so.
But she did not go to see him until 2 weeks after the accident, did she?
Correct.
And her only complaint at that point to her family doctor was that she was having trouble sleeping, wasn't it?
believe so based on the notes. I don't actually recall what she reported to Dr. Bombay directly.
Well, if I represent to you that Ms. Hertz has testified that her only complaint to her doctor was sleeping problems, you'd have no basis to disagree with that, correct?
Correct.
Dr. Bombay prescribed her a sleeping pill at that visit, didn't she?
That's my understanding.
But Ms. Hertz stopped taking the sleeping pills a few days later, correct?
Correct.
You haven't seen Dr. Bombay's records, have you?
I have not.
And you never sought to obtain his records?
That's correct.
Or asked Ms. Hertz to obtain them and give them to you, right?
That's correct.
You've never had any contact with Dr. Bombay about Ms. Hertz or her past medical history, correct?
I'm sorry, can you repeat that?
Sure.
Yeah.
You've never had any contact with Dr. Bombay
correct.
about Ms. Hertz or her past medical history, have you?
That's correct.
So in looking at the differential diagnosis you did here, when Ms. Hertz first came to see you, she told you that she was in good health prior to November 18th, didn't she?
That's correct.
And you relied on that statement in forming your opinions in this case, right?
Correct.
You never took any steps to verify that information, did you?
Well, the history is in and of itself the verification of that to a degree.
The patient's own history,
That's correct.
but you never obtained or reviewed any medical records from prior to your treatment of her, right?
That's correct.
You never talked to any of her physicians who had treated her over the years, did you?
That's correct.
You never obtained her pharmacy records to see what medications she may have taken in the past.
Correct.
You never talked to her family and friends about any symptoms she had ever experienced in the past.
Well, actually, sorry, to correct that statement, regarding the medications, part of our initial interview is called a medication reconciliation. And so pharmacy records and these electronic medical records automatically populate with that information. We just tick off whether or not they're taking it. So that is actually part of our historical component.
You're saying that when you first saw Ms. Hertz, her medication just magically popped up on your screen?
It's not magical. Actually, it's part of this Obamacare initiative for a one unified electronic medical record. And so, for example, any pharmacy prescribed medication or any health system that actually shares an electronic medical record automatically ports that into our system. And then we have to do, by law, what's called a medication reconciliation, meaning we have to go through those records and say, oh, you've been prescribed this, are you taking this, and why are you taking this? And that's the definition of medication reconciliation.
But that's not contained in any of your medical records, and you haven't produced anything about her past medications, have you?
Well, I mean, by doing medication reconciliation, if it's not an active medication, then it doesn't actively populate into the record. That's correct.
Okay, so now I get it. You wouldn't know any prior medications that she had taken in the past. You would just know any medications at the time, is that right?
Well, there are some medications that have been, for example, sent to a pharmacy. Patients don't necessarily fill those, so you might say, oh, are you taking this medication? No? Oh, okay, why not? And then that information, that discussion is not always documented extensively in the chart, but it will drop off of the chart if you say the patient's not taking it, because you've reconciled their active medication list, which is the only thing that's required to be documented, and the fact that you've done medication reconciliation.
Bottom line, Dr. Neuro, no medications are mentioned in any of your records or in your report, correct?
Correct.
Now let me back up. If you did look at her prior medical records and saw that she had actually suffered some of the same issues in the past as she is now, that could impact your opinions in this case, correct?
Yes.
But you didn't do that, did you?
Can you restate that question?
You didn't look at her past medical records, right?
Correct. I didn't have the extensive past medical records of her entire past.
Isn't it true, Dr. Neuro, that this is not the first time that Ms. Hertz has had to seek mental health treatment?
From my understanding after the fact, that is correct.
So you're aware then, it sounds like, that Ms. Hertz actually had to see a psychiatrist when she was in college, correct?
Yes, that is my understanding.
And that would have been important for you to know as you were treating her, wouldn't have been?
It could have been an element that was important. That's correct.
Now on direct, you told this jury that you